Okay, so hi there. It's me again. So, for this video, I'll be discussing stages of execution, conspiracy, and proposal to commit felonies. So, the first thing that we'll discuss is the stages of execution. So, formal crimes. What are formal crimes? These are crimes that are consummated in one instant. So, walang attempt. It is punishable only when it is consummated. So, there are crimes that are consummated by mere attempt or proposal by overt act, such as flight to enemy's country, and those that are consummated by mere agreement, such as illegal betting and corruption of a public officer. So, ano naman yung material crimes? So, ito yung mas common. These crimes are committed with 3 stages of execution. So you've probably heard of these stages of execution before. It could be in the attempted stage, frustrated stage, or consummated stage. So for attempted, the offender commenced the commission of the felony directly by overt act. So na-discuss na natin previously kung ano yung overt act. But the offender does not perform all acts of execution by reason of some cause or accident other than his own spontaneous desistance. So the difference between an impossible crime, which was previously discussed, is that in impossible crime, the inherent impossibility is there is inherent impossibility in the execution of the crime. So pwedeng legally impossible or physically impossible. However, sa attempted, possible siya. Walang legal impossibility, walang physical impossibility. Possible siya, pero hindi siya natuloy. Yun yung difference. Sa impossible crime kasi, hindi siya natuloy kasi impossible nga siya. Sa attempted naman, hindi siya natuloy because of some cause or accident other than the offender's own spontaneous desistance. So, in kidnapping, for example, it is at its attempted stage if the detention is partial. Attempted rape naman, well, tricky tong rape kasi sabi, yung rape daw, consummated lang, walang frustrated stage. But then may jurisprudence na nagsasabi na merong attempted rape if there is an intention to lie and have sexual intercourse. So, which is absent in the consummated act of lasciviousness. Kasi kapag hindi naman, yung elements ng rape kasi, merong yung sexual, yung male sex organ is nag-touch, so penetration na yon sa female sex organ. So considered yun as rape. Syempre may iba pang elements, no? Pero ayun, consummated na yun agad. Hindi kailangan full-on penetration. Kapag hindi naman dumating sa ganyan, usually, acts of lasciviousness. Pero yung difference is, magiging attempted rape siya at hindi acts of lasciviousness. If clear sa actions na yung intention talaga ng offender is to penetrate and to have sexual intercourse or carnal knowledge with the victim. So, yan. Pero mahirap i-prove yung frustrated rape, kaya may jurisprudence na nagsasabing walang frustrated rape. Anyway, more on that when we discuss rape na siguro. So, phases of a felony. Iba na yung phases sa stages. Yung phases ng felony, mayroong subjective phase and objective phase. When you say subjective phase, it is that portion of the act constituting the crime starting from the point where the offender begins the commission of the crime, again through overt actions, to that point which he has still control over his acts, including its natural course. So, hindi pa, kumbaga, meron pa siyang pwedeng gawin para hindi matuloy. Yung objective phase naman, natapos na lahat ng acts of execution. Pag dumating na sa point na to, basically wala ka namang gagawa Kasi, yung logical consequence talaga ng ginawa mo, magre-result na talaga sa crime. Magre-result na talaga sa damage, sa injury, or sa loss sa victim. So, elements of an attempted felony. The following are the concurring elements of the attempted stage of a felony. So the offender commences the commission of the felony directly, again, by external or overt acts that have a direct connection with the crime intended to be committed. Hindi lang yung iniisip mo. Dapat may external action. The offender does not perform all the acts of execution which should produce the felony. And lastly, the non-performance of all acts of execution was due to cause or accident other than his own spontaneous desistance. So, isa-isayin natin yung terms that were mentioned. When you say overt or external act, again, it's some physical activity or deed indicating the intention to commit a particular crime. It's more than just, the mere planning or preparation, which, if carried out to its complete termination following the natural course of things, without it being frustrated by external obstacles nor by the spontaneous desistance of the perpetrator, it will naturally and logically ripen into a concrete offense. So it can be a preparatory act, and it can be an act of execution. By preparatory act, it's not just a mental activity. Again, it must be an overt or external act. So when you say preparatory act, it's you're devising means or measures necessary for the accomplishment of the desired object or end. So like for example, you're preparing your attack, or you're already purchasing some things necessary for you to commit the crime, or you're already starting to strategize, the methods of your attack, things like that. When acts of execution naman, it has the logical relation to a particular or concrete offense and is already punishable under the revised penal code. When you say desistance, it is the act of discontinuing the execution of the felony, which will negative criminal liability of the offender when done during its attempted stage. Tinigil mo yourself. You desisted. Spontaneous desistance is an absolutory cause which negates criminal liability kapag nasa subjective phase ka pa lang. Hindi mo tinuloy kasi kinonsensya ka, ganyan. So you will be rewarded by it by, not wala kang liability kasi di mo natuloy at walang loss, walang injury, walang damage sa part ng victim mo. Hindi mo nagawa yung crime. Okay? Probably nag-prepare ka pero di mo tinuloy. So walang effect. Hindi ka makukulong or hindi ka magsasuffer ng any form of penalty because of doing acts na nasa subjective phase pa lang. Tapos, nag-desist ka. That's why, sa attempted stage, yung sabi, hindi siya natuloy because of some cause or accident other than the offender's spontaneous desistance. Why? Kasi pag attempted stage, meron ka ng liability. So, kapag nag-desist ka, wala kang liability. Pero pag hindi lang siya natuloy other than your own spontaneous desistance, may liability ka kasi gusto mo siya sanang ituloy. Buti na lang hindi natuloy. Kaya lesser yung penalty mo kasi attempt lang. But, alam mo yun, tutuloy mo sana yun eh. Naswertehan lang na hindi natuloy. Parang ganon. Legal desistance is a desistance referred to in law which would obviate criminal liability unless the overt or preparatory act already committed in themselves constitute a felony other than what the actor intended. So it is made during the attempted stage. Factual desistance. Factual desistance is the actual desistance of the actor, and the actor is still liable for the attempt. It is one made after the attempted stage of the crime. There's no legal effect because the law recognizes desistance only at the attempted stage. So what is an indeterminate offense? It is one where the intent of the offender in performing an act is not certain. The accused may be convicted of a felony defined by the acts performed by him up to the time of the desistance. The intention of the accused must be viewed from the nature of the acts executed by him and the attendant circumstances, and not from his admission. So, punta naman tayo sa frustrated stage. Frustrated stage siya when the offender performed all acts of execution that would naturally produce the felony. as a consequence. So, pag gawa mo na yung all acts of execution, nasa objective phase ka na. But, the felony was not produced by reason or cause independent of the will of the perpetrator. Hindi na to parang desistance kasi nagawa mo na lahat eh. May desistance lang siya kapag attempted stage na, well, bawal nga yung desistance para sa attempted stage, no? What I mean is, pwede ka lang mag-desist kapag nasa subjective phase ka na, pero pag nasa objective phase ka na, wala na, hindi na material yung pag-desist mo kasi nagawa mo na lahat. Natural course of things, whatever you intended, the crime you intended, it will ripen. So, it's out of your control. You've done it, 'di ba? Hindi na pwedeng mabawi. However, hindi na produce yung crime because of some reason na not within the control of the offender. So, yun. Paano natin malalaman kung frustrated? Kasi it can be quite confusing, right? So, malalaman mong frustrated if, for example, there's injury. The nature of the wound can actually determine whether the crime is frustrated or attempted. So, if yung wound is fatal or mortal, it means that there was really an intention to kill, and that, the acts of execution, nagawa mo na eh. What are the acts of execution? When you try to kill someone, for example, with a knife, you stab the person, right? You stab the person where the person would die, diba? Mortal. And talagang, you did it na. Completed the acts of execution kasi naturally after inflicting those injuries which caused mortal wounds or fatal wounds, that person should naturally die as a logical consequence, as a natural consequence. However, for some reason, that person survives. So that is a frustrated homicide or frustrated murder, as the case may be. May kinaiba yung homicide at murder if it's just mere killing, homicide if murder if attended by qualifying circumstances, which we will discuss later. No? So, pagka ganun, patay na dapat kaso may nangyari. That's why di namatay. Pag attempted kasi, hindi ka naman mamamatay dahil dun eh. Andun yung intention to kill someone. Like, nag-inflict ka ng wounds or like sabihin, papatayin kita. Pero hindi natuloy. So, attempted. Kasi hindi siya mamamatay sa ganun lang. Pero pag yung injury or yung wound, wala nang magagawa, mamamatay na dapat. Pero for some reason, di namatay. Frustrated. I hope that makes sense. Even if the offender later does something to prevent the consummation of the crime, such offender is still liable for criminal liability at its frustrated stage, even if the crime did not result, provided that the circumstance is independent of the perpetrator's will. If the circumstance is entirely dependent on the perpetrator's will, the offender is only liable for the damages and injuries sustained by the victim. There's no frustrated estafa, there's no frustrated theft, and there's no frustrated robbery. There's also no frustrated kidnapping. If partial, it's attempted. If full, it's consummated. Again, as discussed earlier, there's no frustrated rape. It's either attempted or consummated. The moment there is slight penetration, kahit hindi pa siya talagang full penetration, that's also already considered as consummated. No frustrated stage for formal crimes, as mentioned before, such as threats, coercion, alarms and scandal, slander, or acts of lasciviousness. No frustrated stage for crimes that require participation of two persons, such as adultery, concubinage, and corruption of a public official. Direct and indirect bribery has no frustrated or attempted stage, since the mere agreement consummates the crime. No frustrated or attempted stage for physical injuries, because these crimes are punished. Because these crimes are punished according to the results and not the intention of the accused. So, clear na yan. Elements of a frustrated felony. The following are the concurring elements of the frustrated stage of felony. Sorry, I'm making changes in notes as I go along. Okay, the offender performs all the acts of execution, and all the acts performed would produce the felony as a consequence, but the felony is not produced by reason of causes independent of the will of the perpetrator. So let's go to consummated na, kasi if we've discussed frustrated ng fully. Consummated is, of course, elements necessary for its execution and accomplishment are present. Tapos na. Nagawa na. Yung kung ano yung goal, nagawa na. Kung yung goal is pumatay, namatay na. Magnakaw, nakuha na. Ganon. Mere attempt to flee the country is consummated. Okay? Consummate ka, yung attempt na. Mere solicitation is already abuses to chastity in its consummated stage. Infliction of injuries, whether slight, less serious, or serious, is already in its consummated stage, provided that, of course, the offender sustained an injury. Kasi kung walang injury, di ba? Again, as mentioned before, walang frustrated, walang attempted physical injuries kasi the crime is punished according to the results, and the result is the resulting injury. So, consummated agad. Kung walang injury, hindi yan, walang attempted physical injury. Kapag sasaktan kita, hindi yan attempted physical injury. It's more like threat, diba? Threat yon. So, pwede siyang liable for threat. Unless and until may injury. Hindi pwedeng masabing liable for physical injuries. What else? Ayun, kung tatamaan ka sana pero wala namang injury, pwede ring unjust vexation kung walang threat na ginawa. Like, na-hassle ka lang, no? Or na-stress ka lang sa ginawa niya. So, yun, pwedeng unjust vexation. Oral defamation and slander by deed. Okay, ito din. Has no attempted or frustrated stage, only consummated stage. So, may mga cases to. Mere touching of the external genitalia by the penis capable of consummating the sexual act is already consummated rape. Adultery is an instantaneous crime which is consummated at the moment of the carnal union. Immediately accepting gifts by a public officer by reason of his office consummates indirect bribery. Direct bribery is also immediately consummated. In corruption of public officers, the concurrence of the will of both parties, such as that when the offer is accepted, the offense is consummated. If the offer is rejected, however, it is merely attempted. In theft, the unlawful taking immediately consummates the offense, and the disposition of the thing is not an element thereof. So, the moment na kinuha, consummated theft na yan. Regardless kung napakinabangan ba niya yung kinuha niya, kung nabenta ba niya yung kinuha niya, wala na tayong pake doon. So, sa CRIM 2, we will study the elements of each crime. So, kung anong elements, pag kompleto ng elements na yun, consummated na yan. Arson is consummated in the mere act of setting a house or property afire. Okay. So, mag-cases tayo ng konti. Hanap tayo ng magandang case. Okay. Itong Balero versus People, ano to, may pumasok sa kwarto niya. Yung offender pumasok sa kwarto niya. Tapos, sobrang hindi ko na ano yung details ng case. Yung ginawa niya is may chemical yung panyo. Chloroform yata to. Hindi ko sure na. Tapos, kinover yung mouth ng victim, tapos nag-fight off ng victim. Tapos, ginawa ng victim is, she grabbed the sex organ of the offender and then squeezed it and then umalis, diba? May attempted rape pa, wala. Again, para maging attempted rape, dapat clear na yung intention is not just to molest someone but to really perform the sexual intercourse through overt actions, no? Etong Valenzuela versus People, ito yung Tide yung detergent. So, kinuha na yung ninakaw na boxes of detergent dun sa mall. Kinuha na. SM Hypermarket yata. Nakalimutan ko na. Tapos, pagkakuha, niload na sa taxi. Tapos, napigilan. Diba? Frustrated theft ba? Kasi hindi pa naman nakaalis dun sa compound. Pero nakaalis na dun sa building. Ninakaw na. Answer is no, consummated na agad. Kasi all elements sa theft andyan. Nakuha na na-take na. So, hindi kailangang na-dispose, hindi kailangang talagang nalabas or nabenta. Diba? Yung importante is, ninakaw na siya, nakuha na siya. Nag-gain na. Diba? Intent to gain nga Yan, nag-gain na nga. Na-come into possession na. Okay. Sorry, parang naguguluhan ako sa bangs ko. Alright. Ano pa yung mga cases dito na pwede? Eto, nahuli na nagtatry buksan yung isang store. Okay. Ino-open nila with an iron bar yung store. Tapos, nasira nga yung board and fastening sa wall. Pero nahuli ng pulis. May attempted robbery ba? Hindi natin sure. Kasi hindi napakita through overt actions na yung purpose is to rob So, yung kaso sa kanya dito is he was held guilty of attempted trespass to dwelling kasi apparently dito rin natutulog sa store yung may-ari. Madaming kaso actually, but pili lang tayo. Yung iba kasi napaka-straightforward naman Medyo hindi. Yung maraming cases dito, yung wounds, yung nagde-determine if frustrated or attempted murder. Ito naman sa case ni Orita, yung penis hindi fully na-insert sa vagina. However, yung portion ng penis, yun yung nakapasok, hindi full penetration. Again, pag ganito, consummated rape. Kahit maliit lang na portion yan, basta kahit nga dumapi lang sa sa orifice ng babae. Kahit andito Rape is considered consummated despite the fact that the attacker's penis merely touched the external portions of the vagina. Okay, let's go to conspiracy. So, conspiracy exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. Again, hindi lahat ng conspiracy punishable. Ano lang tayo, way of committing a crime. Yung pag may conspiracy, as a general rule, share kayo sa liability. So, we conspired with each other. So, yung liability, pare-parehas tayo dyan kasi nag-conspire tayo. So, although meron iba-ibang levels lang like principal, accomplice, accessory, ganon. Pero meron namang crimes wherein yung mere conspiracy punishable na. Like, hindi mo lang hintay. Basta nag-conspire kayo to do this, meron na agad penalty. Pero normally, konti lang yung crimes na ganun. Pero normally, yung conspiracy is parang way lang siya to commit a crime and i-discuss lang yung liability or yung degree ng liability ng mga offenders. So, when conspiracy is established, the responsibility of the conspirators is collective, not individual, rendering all of them equally liable regardless of the extent of their respective participation. Pero may differences yan sa penalty kapag ka, for example, principal ka, kapag accomplice ka lang, pag accessory ka lang, pag binenta mo lang, syempre hindi kayo pare-parehas ng Accordingly, direct proof is not essential to establish conspiracy as it can be presumed from and proven by the acts of the accused pointing to a joint purpose, design, concerted action, and community of interest. Ito yung laging phrases na nasa jurisprudence pag may conspiracy. Joint purpose or common design or concerted action or community of interest. Conspiracy to commit a crime is not punishable as a general rule since they are only a preparatory act. Again, unless there is a law that specifically provides a penalty therefor. However, if the crime subject of the conspiracy has actually been committed, it shall be deemed absorbed in the crime. So, hindi mo siya ipipinili sa conspiracy to ganito tapos ganyan kung wala namang crime na kung yung mere conspiracy is not punishable. Again, way lang siya to commit the crime. So, yung crime, for example, nag-conspire sila to rob, diba? So, robbery. Hindi yan conspiracy to robbery. Hindi ganon. Kasi, yung mere conspiracy to rob is not punishable. Dapat, mangyari muna yung robbery. Diba? Pwedeng attempted robbery, sure. Pero, nagde-determine yung conspiracy dito ng liability. Yung mere conspiracy, hanggat di nangyayari, diba? Hindi liable. So, kailan ba yung mere conspiracy nagiging liable yung tao? Kailan punishable? So, conspiracy to commit treason, that's one. Conspiracy to commit rebellion, insurrection, coup d'etat, sedition, monopolies and combinations in restraint of trade, selected acts committed under the Dangerous Drugs Act, arson, terrorism under the Human Security Act, espionage, Anti-Child Pornography Act, access device fraud, and money laundering. So, konti lang to. Ito lang yung mga mere conspiracy punishable na. Yung Human Security Act na repeal na to ng anti-terrorism law yata. So, ganon. Hindi ko sure. Basta na-repeal na yan. Hindi ko sure yung pangalan ng anti-terrorism bill yata. Bill. Hindi bill. Kasi bill kapag hindi pa napasa. Law na yon, act. Conspiracy once found continues until the object of it has been accomplished and unless abandoned or broken up. Okay. To hold an accused guilty as a co-principal by reason of conspiracy, he must be shown to have performed an overt act in pursuance to the furtherance of complicity. There must be an intentional participation in the transaction with a view to the furtherance of the common design and purpose. It is not necessary to prove a previous agreement to commit a crime if there is proof that the malefactors have acted in concert and in pursuance of common objectives. Direct proof, again, as mentioned, is not essential to show conspiracy since it is by its nature often planned in utmost secrecy and it can be seldom proved by direct evidence. In determining whether conspiracy exists, it is not sufficient that the attack be joint and simultaneous, for simultaneousness alone does not of itself demonstrate the concurrence of will or unity of action and purpose, which are the basis of the responsibility of the assailants. To hold one as a co-principal by reason of conspiracy, it must be shown that he performed an overt act in pursuance of or in furtherance of the conspiracy, although acts performed might have been distinct and separate. This overt act may consist of active participation in the actual commission of the crime itself, or it may consist of moral assistance to his co-conspirators by being present at the time of the commission of the crime, or by exerting a moral ascendance over the other co-conspirators by moving them to execute or implement the criminal plan. Mere presence at the scene of the crime is not by itself sufficient to establish conspiracy. Unless, di ba, nakasulat. Kasi, meron yata yun sa anti-hazing law na parang if nandun ka, liable ka, there must be evidence of, ito general rule lang to, there must be evidence of actual cooperation rather than mere cognizance or approval of an illegal act. Okay. Knowledge of or acquiescence in or agreement to cooperate is not enough to constitute one a party to a conspiracy. Absent any active participation in the commission of the crime with a view to the furtherance of the common design and purpose. So, conspiracy by prior agreement exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it, in which case a conspirator is liable as long as he appeared in the scene of the crime unless he is the mastermind. The liability of the conspirators is only for the crime agreed upon, except when the other crime was committed in their presence and they did not prevent the commission. That's one. Second, when the other crime is the natural consequence of the crime planned. And third, when the resulting crime was a composite crime. So, ayun. So, kahit for example, nag-agree na robbery lang. Pero pagdating doon, may ni-rape. Diba? So, kung robbery yung pinag-usapan, sa robbery lang liable yung conspirators. Kung may isa dyan na ng rape, hindi ka na liable doon unless nakita mong nire-rape, wala kang ginawa. Hinayaan mo lang. So parang kinonsent mo or tinolerate mo. Kung tinolerate mo yun, hinayaan mo lang, andun ka rin, nanonood ka, liable ka rin sa rape. Robbery with rape din yung sayo. Yung sa iba na hindi alam na may rape na nangyayari, yung pinag-usapan, robbery lang sa kanila. Pero dun sa nakakaalam at walang ginawa or hinayaan lang, liable din sila sa robbery with rape. Or, liable din, kunwari, kapag yung pinag-usapan is ganito, di ba? Pero, dahil kailangan siyang gawin, yung crime na to, for example, ang mang-hold up kayo, tapos wala kayong baril, so gumamit din kayo ng illegal firearms. So, naturally, pwede rin kayong maging liable kahit na yung pinag-usapan is robbery. Kasi yung means nyo sa robbery, ganun eh. Kailangan nyo mag-commit ng another crime as a requisite to commit this other crime that you really intend. Or when the resulting crime was a composite crime. Implied conspiracy. Conspiracy is deemed implied when the malefactors have a common purpose and were united in its execution. Spontaneous agreement or active cooperation by all perpetrators at the moment of the commission of the crime is sufficient to create joint criminal responsibility. There is an implied conspiracy when two or more persons aimed by their acts towards the accomplishment of some unlawful object, each doing a part so that their combined acts, though apparently independent, are in fact connected and cooperative, indicating a closeness of personal association and the concurrence of sentiment. In other words, there must be unity of purpose and unity in the execution of the unlawful objective. Perfect example, like parang plunder, diba? Independent acts, pero as a whole, part pala kayo ng mechanism for plunder. Conspiracy can be inferred from and established by the acts of the accused themselves when said acts point to a joint purpose and design, concerted action, and community of interest. The co-conspirator must do an act which shows his unity of purpose and design with the other offenders. Mere presence at the scene of the crime without more will not make a person liable as a general rule. And this is true even if he approves of the acts of the offenders. Mere knowledge, acquiescence to, or agreement to cooperate is not enough to constitute one as a party to conspiracy absent any active participation in the commission of the crime with a view to the furtherance of the common design and purpose. Conspiracy transcends companionship. In the absence of conspiracy or unity of criminal purpose and intention immediately before the commission of the crime or community of criminal design, the criminal responsibility arising from the acts directed against one and the same person is individual and not collective. In determining whether there is implied conspiracy, it must be based on first, overt acts done before, during, or after the commission of the crime, or words, remarks, or language used before, during, or after the commission of the crime. They must be distinct from each other, independent or separate. They must be closely associated, related, linked, and coordinated. They must be of common criminal design, joint criminal interest, unity of criminal purpose, or concerted action geared towards the attainment of the felony. So, ulit-ulit yung terms, diba? Ganun kasi pag conspiracy. Common design, community of interest, unity of purpose, concerted action. Ganun yung mga keywords. So, if sasagot sa exam, if conspiracy, yun yung hahanapin and yun yung ibibigay na keywords. Arias' doctrine. All heads of offices have to rely to a reasonable extent on their subordinates and on the good faith of those who prepare bids, purchase supplies, or enter into negotiations. One who signs or initials documents in course of transit in the conduct of the agency's standard operating procedure, diba? Minsan, pipirma lang yung boss mo dyan, does not automatically become a conspirator in a crime committed at a stage where he had no participation. So, kunwari may illegal dyan, tapos pinasa sa managing director or sa CEO, tapos pirma lang siya dyan, diba? Pero, hindi nga binasa, okay? May kakulangan, may negligence dyan. Pero doesn't mean na pumirma siya dyan, part na siya dyan. Kung part naman talaga ng duty niya as SOP, pumirma dyan eh. Kasi usually, nagre-rely siya na pag umabot na sa office niya, okay na. Wheel conspiracy. The wheel conspiracy occurs when there is a single person or group which is called the hub. So, imagine tayo ng wheel, diba? Wheel. Like yung wheel. Pwedeng wheel ng kalesa, yun yung mas magandang or like yung wheel ng diba? Hindi yung wheel na modern na car. So yun, wheel. Kunwari wheel ng kalesa. Hub yun. Tapos, diba merong center niyan. Tapos merong mga lines. Yun yung spokes, diba? So, may single person or group, yun yung sa gitna, yung hub, na nagdi-deal individually. Diba may lines. Circle, tapos basta yun, yung lines na yun, diba, yun yung spokes, yun yung gitna, diba, connected lahat ng parang spokes dun sa gitna. Kasi yung hub, yun yung nagdi-deal individually dun sa mga other persons or groups. So, this spoke typically interacts with the hub at hindi siya nag-interact dun sa ibang spokes. Ganon. Parang may headquarters, merong central may center, which could be a person or a group. Tapos, ito yung kinakausap ng lahat. In the event the spokes share a common purpose to succeed, there is a single conspiracy. Pero sa wheel conspiracy, lahat ng spokes nagko-connect dun sa hub. Tapos yung mga spokes, hindi sila nag-interact sa each other, lahat through the hub. However, in instances when each spoke is unconcerned with the success of the other spokes, maraming multiple conspiracies. An illustration of a wheel conspiracy wherein there is only one conspiracy involved is a conspiracy alleged sa information dun sa plunder case filed against former President Estrada and his co-conspirators. So, si President Estrada daw sa case na yun yung hub, tapos yung iba are just the spokes. Chain conspiracy naman exists when there is successive communication and cooperation in much the same way as with the legitimate business operations wherein there is a manufacturer and wholesaler, and the wholesaler and the retailer, and the retailer and the consumer. So, pag medyo linear siya. So, an illustration of this is dun sa United States case versus US versus Bruno, wherein merong 88 defendants indicted for conspiracy to import, sell, and possess narcotics. And yung case involves several smugglers, okay, na binili sa retailers. And then yung retailers naman, may kinukunan din. So, parang merong mastermind, ganon. May levels lang. Conspiracy must be established by proof beyond reasonable doubt. It must be proven as convincingly as the criminal act itself. Like any element of the offense charged, conspiracy must be established by proof beyond reasonable doubt. For a co-conspirator to be liable for the acts of the others, there must be intentional participation in the conspiracy with a view to further a common design. Except for the mastermind, it is necessary for the co-conspirator should have performed some overt act of the actual commission of the crime itself, active participation as a direct and indirect contribution in the execution of the crime, or moral assistance to his co-conspirators by being present at the commission of the crime or by exerting moral ascendancy over the other co-conspirators. So, conspiracy is presumed in hazing. Ito yung sasabi kong exception kanina. Kasi RA number 8049 presents a novel provision that introduces a disputable presumption of actual participation. Again, it's just a presumption. And which, meaning pwedeng i-rebut, which modifies the concept of conspiracy. So, sabi sa anti-hazing law na the presence of any person during the hazing is prima facie evidence, prima facie evidence of participation as principal unless he prevented the commission of the punishable acts. The provision is unique because the disputable presumption arises from the mere presence of the offender during the hazing, which can be rebutted by proving that the accused took steps to prevent the commission of the hazing. So again, ito yung exception dun sa general rule na mere presence hindi ka liable. Dito sa hazing, mere presence dun sa hazing, kung hindi mo pinagilan, liable ka. Conspiracy is deduced from the conducts of the perpetrators. So jurisprudence consistently teaches us that conspiracy may be deduced from the mode and manner in which the offense was perpetrated, showing that at the time of the commission of the offense, all the perpetrators have the same purpose and were united in its execution. The records show that dapat the records should show that there was yung conduct ba, kailangan ma-explain na in connection or in furtherance siya dun sa crime, like sa common design. Hindi pwedeng i-assume lang. Kailangan kasi i-prove siya, di ba? Alright. Proposal to commit a felony naman. Yung proposal, again, like conspiracy, hindi siya punishable unless the law states na punishable siya. Okay? So, paano ba may proposal? A person has decided to commit a felony and proposes its execution to the others. So, to others. So, kailan punishable yung mere proposal? Sa treason, sa rebellion, insurrection, coup d'etat. Okay. So, tignan natin kung ano yung mga interesting cases. Usually, mga cases for conspiracy, ano to ay yung hazing cases or like plunder cases. Meron kay Estrada, meron kay GMA. Ayun. So, I guess I'll stop here for now. I'll just take a break and then I'll continue with the circumstances, justifying, exempting, mitigating, alternative, aggravating, and alternative circumstances. Okay. Tapos after ng circumstances, madami yan eh. After ng circumstances, I'll stop muna the criminal law review series. And then I'll start uploading civil law naman, the general provisions of the new civil code, personality, and then family code. And then I'll stop there, and then I'll start naman the political law review playlist, and then I'll be discussing, the first parts of Constitutional Law 1 up to the Legislative Department if kaya, or the Executive Department, or baka hanggang Judiciary na, sure. And then I'll go back to criminal law, and then alternate na sila. Pero yung goal ko for before I start the civil law review playlist is matapos until the circumstances for criminal law review. Okay, see you later.